The case we'll be discussing today is Roberson versus Rochester Folding Box Company. It's a case mostly related to the right to privacy, though it does touch on separation of powers. But before we get to the law of the case, we should quickly discuss the facts. Roberson's picture was used without her permission as the centerpiece for an advertisement for flour by Rochester Folding Box Company. This caused her to be noticed by a few of her friends in this photo, and that caused her a bit of distress. They printed her photo about 25,000 times, and it was posted in many places, warehouses, salons, and a few other places. She ends up suing them for about $15,000 or $4,500 in today's money. The case was then brought before the New York Supreme Court. Now, in New York, the courts are named a little differently. The Supreme Court of New York is actually their lowest court. I know, makes sense. Above that is the Appellate Division of the Supreme Court, followed by the Appeals Court. Both the Supreme Court and the Appellate Division of the Supreme Court agreed that she had the right to be protected from her photo being printed without her permission, and she was owed at least some damages. The Appeals Court, the final court, disagreed in a ruling 4-3. Now, they were asking two questions. The two-pronged test here was, is there a cause of action in law and a cause of action in equity? A cause of action in law would be any cause in which there is law supporting your claim, right? So a cause of action in law might be, well, he murdered him. That is a cause of action in law. There are laws that have been violated. Cause of action in equity is a question of whether or not the court has sufficient proof and evidence to force an action, be that the delivery of monetary damages, or in this case, a cease and desist, hoping to prevent them from further printing the photograph, as well as the monetary damage requested. Now, the court made it clear she had made no complaint of libel, so libel was not the question here. This question was whether they could use her photo, not whether they could use her photo in a defamatory manner, as the photo was not considered defamatory. It was considered a quality portrait in the terms of one of the judges. So the cause of action in equity would be, again, an attempt to cease and desist, as well as the turnover of the monetary damages. Now, there's a couple quotes from this case that I think are really quality that should be heard, and that'll give you a really good idea of how the court came down. The court in the appeals case, again, came down and said that, no, she does not have a right to privacy, and they'll explain these in these two quotes. It may be said in the first place that the theory upon which action is predicated is new, at least in instance, if not in principle, and that few precedents can be found to sustain the claim made by the plaintiff, if indeed it can be said that there are any authoritative cases establishing her right to recover in this action. Now, that is a quote being used by the appeals court from the Supreme Court, and that's them openly admitting that there is not a lot of evidence here. The court takes this quote pretty derisively and makes it clear that this court is not to legislate. This court is to make rulings. Legislating is for the legislature, and that's where the interesting bit of separation of powers comes in. Now here we see the next quote. If such a principle can be incorporated into the body of law through the instrumentality of a court of equity, the attempts to logically apply that principle would necessarily result in not only a vast amount of litigation, but litigation bordering on the absurd. Now, this is the words of the actual appeals court, stating that this is an interesting cause of action, but the cause of action as applied could lead to some very nonsensical rulings. And courts should always look and make sure that the rulings that come down are logical. Law is not the only thing that matters when it comes to a court. Reason does matter as well, though the law would be the deciding factor here. The right to privacy, once established as legal doctrine, cannot be confined to the restraint of the publication of a likeness, but must necessarily embrace, as well as the publication of a word, picture, or comment upon one's look, conducts, or domestic relations, or habits. This is again saying that if a right to privacy exists, it would be overburdening. It would prevent people from writing about someone, commenting on someone's looks, say, even the president's potentially, right? And if you can't comment on the president's looks, then do you really have a right to free speech? Again, the courts are without authority to legislate here, so they can't invent this right. There's no law that says that they can protect these things. Now, the appeals court here cites a few different cases. I'm going to list all of them, though only one of them really has any important commentary that's relevant. These are just cases that they're citing to explain that these cases, which could be used as a potential framework for a right to privacy, don't work because they're not right to privacy cases, they're property rights or intellectual property cases. The court cites Prince Albert versus Strange, Polar View Photographic Company, though this one even states that, again, a photo lacking a contract has no special protection. A photo taken, quote, on the sly would not be protected. Your likeness in that photo would not be protected. The photo itself would actually still have property rights and intellectual property rights. Glee versus Pritchard, or Gee, my apologies, Abernathy v. Hutchinson, Mayle v. Higby, and Duke of Queensberry versus Sheber. Some of these cases are some very old English cases with some very funny names, like, again, Duke of Queensberry versus Sheber. Again, each of these decisions was rested either on the ground of breach of trust or that a plaintiff had a property right in the subject of litigation which the court could protect. The court cannot protect something if it is not already protected by the law. And so again, this case comes down and it makes it clear that a right to privacy does not exist in law. The New York legislature would go on to establish one in sections 50 and 51 of the New York Code. But that's not really under the purview of this case, of this video. There is a dissent provided in the brief I was provided, and so I am going to discuss it very quickly. This is a dissent by Justice Gray, which just comes with one very interesting quote I quite liked, which is, security of person isn't necessary as the security of property. I think that this plaintiff has the same property in the right to be protected against the use of her face for defendant's commercial purposes. He is in essence arguing that her face, her likeness, is part of her property, and therefore her person is property which can be protected. And with that, we're going to go ahead and close up this quick summary of Roberson versus Rochester Folding Box Company. If you have any questions, put them in the comments below, and I'll do my best to reply. Have a wonderful day.